Does New York City's human rights law prohibiting housing discrimination on the basis of marital status protect unmarried long-term partners? To find out, you have to read McCabe versus 511 West 232nd Owners Corp, but it's 57 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of McCabe versus 511 West 232nd Owners Corporation. The citation for this case is 2024 New York Slip Opinion 06290, published by the New York Court of Appeals on December 17th of 2024. The issue in this case is whether unmarried long-term romantic partners that are in the functional equivalent, essentially, of being married partners are protected by the New York City's human rights law. To understand and appreciate the context of this case, the background that's helpful to know is that New York City's administrative code, that's the law of New York City, 8-1075A1, makes it unlawful to discriminate with respect to sale, rent, or lease. It's like housing discrimination on the basis of many different protected classes, including race, creed, color, national origin, gender, age, disability, sexual orientation, uniform service, height, weight, and marital status, as well as partnership status or immigration or citizenship status. So there's a variety of protected classes for which a person cannot be discriminated in the basis of housing, obtaining housing, either rental, sale, or lease. And what are the facts in this case? The facts are that the plaintiff in this case is someone named McCabe, and she and a person named David Burrows lived in a cooperative building located in the Bronx at 511 West 232nd Street it was a co-op building that was run by the 511 West 232nd Owners Corporation. That's the board that's the co-op board. McCabe had a unit in that building and shares of the co-op, and so did David Burrows, had a different unit in the building and shares. But they lived together for 13 years in David Burrows's unit, from 2006 to 2019. In 2018, while they're both alive, McCabe and Burrows went to the board and said, I want to add McCabe, my longtime girlfriend here, as a shareholder and tenant on Burrows's unit. The board said no. The board said we have a lease provision that allows it for married spouses or domestic related partners, but you need proof that you're either a spouse or a domestic partnership. They didn't have those. They didn't have that proof, so they didn't do that. Instead, what Burrows did is he created a new last will and testament in which he left all of his assets with respect to the unit, to the co-op unit, to McCabe, right? So she will inherit all of the assets with respect to the lease from David Burrows, and also be the executor of his estate. He then died in 2019, and so all of his property then, with respect to the lease, went to McCabe. Meanwhile, the board, realizing that the owner of this unit died, sent McCabe, had her served, a notice to cure and to vacate, saying, you are now living in a unit without the consent of the owner. The owner, by the way, is dead. The owner is David Burrows. He's dead. She then said, well, I'm his spouse. I'm the functional equivalent of his spouse. I'm also inheriting all of his shares with respect to the lease. I want you to assign me his unit based upon these shares and what I inherited. And they said, no, you're not the spouse. We don't have to do that. We can negotiate with you as if you're a prospective buyer, and we can talk to you like that. And she said, no. And she filed a lawsuit and saying, you are discriminating against me based upon my marital status in violation of the New York City's human rights law. That code I just talked about, Administrative Code 8-1075A1. She said that they are violating her rights because they're treating her differently. They're discriminating against her. They're not allowing her to do something because she's not married, and they'd be treating her differently if she was married. Ultimately, the Supreme Court denies this application, says she's not protected by the human rights law because of marital status in this case. The appellate division affirms, and it goes to the Court of Appeals. And the Court of Appeals here comes up with 3 different decisions. There's a 5-judge majority, and then there's 2 dissents by Judge Wilson and Judge Rivera. The majority by Judge Halligan, joined by 4 other judges, is that marital status means a social condition enjoyed by an individual by reason of his or her having participated or failed to participate in a marriage, that a marriage is different than who you are married to. So they say that she's not protected by the human rights law in this case, because the reason why the board won't let her inherit the shares is because there's no proof that she's married to Burroughs. That's different than her being married or unmarried. They're requiring the relationship be with Burroughs, and that's different than the basic institution of marriage. Separate and apart from that, they opine, the majority says, being unmarried is not necessarily protected by the human rights law. There's no specific protection in the classification of groups. It doesn't say the unmarried. It says marital status and domestic partnership. So they say the co-op board was not necessarily wrong to do what they did here. But the two dissents here by Judge Wilson and Rivera are full-throated, strongly worded dissents that basically say marital status in this case does include the plaintiff in this case. First of all, both of them say that, or Judge Wilson in particular says, that the human rights law protects not just people, but groups of people, including couples. So here, the couple of Burroughs and McCabe, that as a couple is being discriminated against because they're not a married couple. And for that reason, it would be on its face. A plain reading of the text would say human rights law is implicated here. And Judge Rivera says we have to reevaluate marital situations in light of the developmental changes of families over the last couple of decades. But ultimately, the important holding in this case is that a five-judge majority here says the human rights law is not implicated here. There's no protection in this particular case because marriage is different than who you are married to. And separate and apart from that, there's no necessary protection for unmarried couples in the human rights law. And that's the case of McCabe versus 511 West 232nd Owners Corp. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.